Good morning, all, and welcome to this public hearing an inquiry into the feasibility of widening the availability of non-custodial penalties in the criminal justice system. This is the 27th meeting of the Joint Select Committee on Finance and Legal Affairs, and this is our second public hearing into this inquiry. I am inviting members of the public to send your comments or questions via Parliament's social media platforms during the course of the inquiry if there is any issue that you would like to raise or question that you would like to have us ask. This morning we are pleased to have with us the Chief Immigration Officer and her team. I believe it's Mr. G1. I can't see so well from here. Mr. G1 Harry Koo, Mr. Sherwin Johnson, and Mr. Anderson Jerome. Welcome all. And we also have representatives of Vision on Mission. I understand that Mr. Wayne Chance is a bit under the weather this morning. So we have Mr. Gordon Husbands and Miss Tamika Bernard. Represent, as I say, it's a bit far for me to see, representing Vision on Mission. Now, having read your name cards, I will invite you, moving from left to right, to personally introduce yourselves to the listening and viewing audience.
Good morning, everyone. I'm Tamika Bernard. I'm a caseworker attached to Vision on Mission.
Good morning, Chair and members of the committee. My name is Gordon Husbands. I'm the Program Director on Vision on Mission with a background of corrections.
Good morning, Madam Chair and members of the committee. I am Charmaine Gandhi Andrews, Acting Chief Immigration Officer.
Good morning, everyone. My name is G1 Hariku. I'm an Immigration Officer 4 attached to our Enforcement Unit.
Good morning, everyone. My name is Sherwin Johnson. I am an Acting Immigration Officer 4 and currently the Administrator of the IDC.
Good morning, everyone. My name is Anderson Jerome. I'm an Immigration Officer 3 attached to the Division's Enforcement Unit.
Thank you. My name is Sophia Choate. I am the chairperson of this committee. So I will now invite members to introduce themselves.
Thank you and good morning. Terence Dialsing, member.
Good morning, Clarence Rambrad, Vice Chairman.
Good morning all. Vidya Gaidin Gopi Singh, member.
Good morning all. Taharko Bika, member.
Thank you, and you will see other persons sitting at the table, and they are members of the Secretariat for this committee. To my left is Mr. Julian Ogilvie, who heads the team. Now, just for the purposes of reminding those who are viewing and listening, I'm going to read out the 3 objectives of the inquiry. 1, to assess the efficacy of non-custodial penalties in dealing with the backlog of criminal cases. 2, to determine whether non-custodial penalties may ameliorate high recidivism rates. And 3, to ascertain what are the critical requirements prerequisites for the wider application of non-custodial sanctions in the administration of justice. It is normal for us to ask a representative from each group attending to make a brief opening statement of about 2 minutes or so. So I will invite the Chief Immigration Officer now to do that.
Thank you very much, Madam Chair. The Immigration Division of the Ministry of National Security thanks the Joint Select Committee on Finance and Legal Affairs for the opportunity to contribute to the inquiry into the feasibility of widening the availability of non-custodial penalties in the criminal justice system. The division is mandated to enforce the Immigration Act and regulations, which set out, among other things, who can legally reside in the country, who are prohibited immigrants and permitted entrants, what the criteria are for remaining in the country legally, the offenses and penalties for those who have breached the legislation, and the process for detaining and deporting the offenders. Prior to November 2009, foreign nationals who breached the conditions of their landing certificate or committed immigration offenses were detained at the nation's prisons. Subsequently, the Immigration Detention Center was opened to house immigration detainees to ensure that they were not treated in the same manner as or exposed to criminal offenders. Detainees come from various countries around the world, and the length of their detention can vary depending on their unique circumstances. Obstacles to repatriation can arise, such as lack of documentation, an inability to identify the detainee, a lack of cooperation by the detainee, and the demands of airlines and transit countries. While the division has improved its processing time from detention to order for removal, these obstacles can prolong the process and ultimately the length of detention. The Immigration Act does set out discretionary alternatives to detention. However, our records show that at least 45% of foreign nationals fail to adhere to the terms and conditions of their release and remain at large in the country. The use of other alternatives, such as electronic monitoring, is a welcome initiative that can aid the division in carrying out its mission of promoting national security by effectively monitoring and controlling the movement of persons into, within, and out of Trinidad and Tobago. My team here today stands ready to address any of the concerns of the committee. Thank you.
Thank you, Chief Immigration Officer. Mr. Husbands, will you be doing the opening remarks?
Yes, I would, Madam Chair. Thank you again. I stand here to represent, or sit rather, to represent Vision and Mission in the absence of Mr. Wayne Chance, who is incapacitated at the moment, so he sends his apology for not being able to attend. Vision and Mission is a non-profit organization which have been involved in resettlement or reintegration of ex-offenders since 2000. We are now under the ambit of the Ministry of National Security, and with the mandate in terms of how can we prepare offenders for a smooth reintegration. And that is done by providing what Vision and Mission has developed called a transition from prison to corrections model, which is the most contemporary approach in terms of reintegrating offenders. And that consists of two components. The first component is developing a curriculum that prepares the individual for reentry, covering topics as prisonization, spirituality, the 10 keys towards reintegration, the aspect in terms of job readiness, and we're trying to expand what we do within the prison for 2019 and beyond because of a grant we received from the European Union to develop an entrepreneur mindset and to develop what we call an incubator in terms of preparing inmates and providing them with the guidance and the capability to go into their own small businesses. Having said that, we welcome the whole aspect in terms of looking at alternative to custody. In another incarnation, I was a Chief Prison Welfare Officer, so I recognize the need to see if we can really decriminalize some of the persons who come in to avoid them being contaminated and to develop what I like to call legitimacy. Who do we really want to send to prison? Do we really want to send all of our offenders to prison? Having said that, though, for that to work, there must be a clear perspective in terms of those offenses, those minor offenses, probably nonviolent offenses, who can be better treated within the community. Again, I believe that the range which I saw here in the document that came to us is too limited. There are far more, a wider scope of non-custodial sentences, which I think I would have the opportunity later on to expand on, both at the pre-trial level, the sentencing level, and of course the post the post-sentencing. So that discussion would ensue. Again, I want to thank the committee for thinking Vision and Mission worthy, to come and share our knowledge and our experiences with this august body.
Thank you very much, Mr. Husbands.
Thank you, Chair. Chair, as you know, I have another joint select to be at, but I do have one question I would like aired because I'm very interested in it. Mr. Husbands, what category of person, or what sort of crime is best suited for non-custodial sentences? 1. 2, what are the range of non-custodial sentences used? But what I'm more interested in, what type of person with the correct aptitude and psychological profile is more amenable to non-custodial sentences?
Thank you, member. To answer the first question pointedly, as I mentioned earlier, it might be for non-violent offenses and particularly for first-time offenses. I know people say they know that there's nothing like a victimless crime, but then sometimes you see a young man might be smoking marijuana, right? That person can be diverted into a rehab center. That person comes before the court, can also be placed on some suspended sentence or a rehabilitation order and divert that person into a treatment. Again, you could suspend the sentence, and if that person completes the program successfully, then you no longer continue the prosecution on that person. In terms of the personality trait, we are looking at persons who seem not to have a history, right, of getting involved with the law. What do I mean by that? And of course, the personality, this is a very difficult thing, but then there are instruments, particularly in corrections. The most contemporary instrument that is being used, they call it the LSCMI, the Level of Service Case Management Inventory, which addresses the history of the individual, the person's educational level, work if the person has at the age of work, in terms of his associations, in terms of if there's any substance abuse, any kind of family issues, in terms of his reasoning level, in terms of his support system, as it were. Again, that instrument is going to be utilized by the probation department, by even magistrates or people in the court who can use that instrument to look at the profile of the individual. You're looking for persons who haven't demonstrated traits of mollification. What does it mean? It means that they do not the value, right, the limit or the impact of their crime. They don't seem to think, that they are obligated to commit this crime. They call it super optimism, that they won't be caught, that they don't demonstrate that level of what they call cognitive laziness in terms of they're going to ensure that they're going to complete any program that they get into, and the others, but I'm trying to make sure that we give a good profile. Again, there's something that in correction that is being utilized is called the criminal mask. In terms of looking at the person, if that person is self-centered, they call it narcissism. If that person hasn't shown that sense in terms of not following through on authority, a dislike for authority, a history of lying and stealing, lack of empathy, and not understanding the keys to freedom. So there are a lot of instruments and there are a lot of profiling that must be done, both by the court, the personnel and under probation particularly, which is supposed to be the agency that's supposed to champion this thing in terms of non-custodial sentences. Again, even the police service, right now they have the authority to caution and warn, right? They can use this particular kind of instrument as well to see which individual, young, nonviolent offender, who doesn't seem to be a habitual offender, that is, who can probably divert
Sure.
to a program, right? So,
thank you, Mr. Husband. That was very helpful. Member, I understand that you have to be in another committee, so you may be excused, but that takes us straight into an issue that we perhaps could begin with when looking at the Immigration Department and how the department deals with detainees. What informs the decision for conditional release? Well, the boss is here, so I guess the boss will say who has to answer.
Thank you, Chair. There are several conditions that must be met for conditional release. One of which the person, or if there are persons who are willing to post a security deposit or a landing deposit with the Chief Immigration Officer. That landing deposit varies by nationality. And also, there must be someone in the public domain that is willing to take care of them, because we cannot place somebody on a conditional release and they have nowhere to go. Thirdly, where they are staying, because we have instances of where police or immigration would have picked up foreign nationals on the streets, where they're living on the streets. Right, so we must have some place to put them. We must have someone who is willing to house them and take care of them. And then the other thing is, how is that person going to be supported? Is that person who is willing to take care of them will take care to all their needs? That is, their financial needs, their social needs, because in Trinidad and Tobago, a foreign national cannot work unless there is a work permit or work permit exemption, or unless they are under the ambit of the CSME. And an important point also in trying to ascertain whether a person could be conditionally released on an order of supervision is actually identifying that person. We've had significant challenges in some cases of actually identifying the person, where the person is not willing to say who they are, where they are from, or they're giving us incorrect information to divert us into another direction. They may have criminal history in their homeland or so. So we have to look at the entire position of vulnerability of that individual, do a risk assessment, and then from that risk assessment, we'll be able to determine whether that person can be placed on a conditional release. Thank you.
Just before I invite other members to ask questions, how do you all liaise with Interpol? Because I would imagine if you're trying to ascertain the identity of someone and you suspect that they may have changed their names because they have criminal convictions elsewhere, does the unit dealing with these detainees, does the unit liaise with the Interpol division in Trinidad and Tobago?
Thank you, Chair. Yes, we do liaise with the Interpol unit. We will fingerprint and photograph the foreign national that we cannot identify, or in some cases that we can identify, but based on the interviews, we suspect that that person may not be telling us the truth. So we do fingerprint, we photograph, and we forward that to the Interpol Bureau. However, the responses depends on the country in which the information is being requested from the local bureau. So we cannot even give a timeline as to how long. In some cases, responses come back quite quickly, within a week, within some days. In other cases, it takes months in order to get information.
Thank you very much. I just wanted to ask some questions about the persons who are on the order of supervision. How many persons are currently under the order of supervision, one? And what issues have arisen with persons who are under the order of supervision?
Thank you, Member. Vice Chair. In 2016, now this is a snapshot, right? So in 2016, we would have approximately 2,000 persons who were placed on orders of supervision. You have to be minded that is from January to December. In 2017, 1,600. In 2018, it was up close to 2,000. And as at 2019, we have approximately 200 persons being placed on orders of supervision. The challenges with respect to placing persons on orders of supervision is, again, what I would have alluded to earlier, in that we may not be able to identify that person in the first instance. There may not be anyone who is coming forward to assist that person in terms of their housing needs, their social needs. So it places the Immigration Division in a sort of a conundrum as to whether or not that person is to be placed on an order of supervision, or whether we may have to detain on, or whether or not we may have to detain that person pending the identification, pending the fact that we may have to get someone who may be willing to take care of that person. Also, what we have to look at is the breaches of the terms of the orders of supervision. Right? There's a reporting structure in place.
Okay, before you go into the second question, I just want to, just for clarity, you gave the figure of 2,000 for 2016, right? Now that means that for the year 2016, there were 2,000 persons under order of supervision.
That is correct.
Right. And then you gave the other years, and then you gave a number for 2019?
Yes.
What
200.
Huh?
200.
So the persons who were under the order of supervision in 2018, don't they continue into 2019?
Yes. Well, this is the 200 is new persons.
Oh, new.
Yes,
right.
yes. The 200 is new persons we will have placed on orders of supervision.
Right.
We have
and then you have the 139 who are in detention.
Yes.
Right. So right now, you would have more than 2,000 under order of supervision.
That is correct.
Right. So the second question I asked was, and you had started to answer, what challenges you have when you were talking about the breaches?
Yes, persons placed on orders and supervision, is, as we mentioned earlier, it's a conditional release. And as part of being placed on the order of supervision, as I mentioned earlier, would be the whole identification issues and the fact that the person is required to pay a bond or have someone pay a bond on their behalf. We must be minded that when the person is placed on an order of supervision, there's a reporting structure in place where they are given a time and place, a date, time and place in which to report to whatever office, be it the Port of Spain office, the San Fernando office, or the Tobago office. And what you're finding in most of the cases is there's an almost 50% breach of that order of supervision, in that they are not reporting. They are in the system somewhere, and they are not reporting. When we check our border management systems, it shows that they are in the country, but they are not reporting to us.
What is the risk to the public of these people not meeting the reporting requirements?
Well, again, it's breaches of the Immigration Act. In some cases, the persons are order deported, but we, in the first instance, will try and see if we can have them report on these orders of supervision. In terms of the consequences, in terms of the not reporting, they are in the system, working without a work permit, studying without a student permit, so essentially breaching the Immigration Act by they being out, not reporting it to the immigration. We cannot monitor them, because essentially that's what we do when we try to place the person on order of supervision. We are not monitoring them. What we're finding also is a lot of the persons who are not reporting on the orders of supervision, when they do come to our attention because of some police exercise or law enforcement exercise, they have criminal offenses. And in some cases, multiple criminal offenses.
Okay, before my colleague, Ms. Senator Obika, asked, I was getting to that. So at the time they are detained by immigration, they do not have criminal records.
In some cases.
They do. And then you found that they commit crimes while they
are on the order of supervision, while they should be on the order of supervision, but they have breached that order of supervision.
Okay, thank you very much.
Thank you, Vice Chair. Chair Sri, I want to ask, is it that the Immigration Division is proposing that all persons, all foreign nationals who are to be placed on a bond be subject to some form of enhanced monitoring, for example, electronic monitoring?
No, that's not what we're proposing. There are some instances where we believe that the persons can be electronically monitored. And I'll give you an example. There are some persons who are order deported, but we cannot effect the deportation because they have criminal matters before the courts, and the courts may have granted them bail. In a lot of the instances, those persons, we either have them in detention, depending on the nature of the criminal offense or the immigration offense, or we place them on an order of supervision because their matters go on for a long period of time. And the question of keeping them in detention, in the detention center arises. And of course, we have lots of writs of habeas corpus, etc. And if they're granted bail, why should they be in the detention center? So some of those persons, when we do put them on orders of supervision, they fail to report to us because they don't see the immigration reporting structure as important. They might have reporting requirements on the conditions of bail, but we have no idea where they are. And sometimes, like Mr. Hariko has mentioned, they come back to us having committed another criminal offense. So those persons are some of what we are thinking as part of their conditions of bail. They might be, because they have been order deported. They then can be the electronic monitoring system can be used in cases like that where we know where they are. Some of them have actually left the country clandestinely. So there are a number of situations in which we can utilize the electronic monitoring, and that's just one example of what it is.
It seems to me that what you're telling us, or what the department is telling us, is that these orders of supervision are not working in the way in which they ought to. And sometimes when persons under these supervision orders are allowed their conditional liberty, they go out and they commit crimes and so on. Has any thought been given to having the person report, instead of to the immigration office, which opens 8 to 4, having the person report to a police station? So if they're on bail, for example, and they have to report to the police station, they can report at the same place and satisfy both conditions. And the systems, the government systems, don't have to duplicate their efforts to ensure that someone has to report 2 places. That's one thing. And the other thing is, it might be, I suppose, more of a deterrent to someone who's thinking about committing a criminal offense if they know that they have to go and report to a police station as opposed to an office at the immigration officer's department. So has any thought been given to that option or possibility?
Thank you. We have, usually when a person is granted bail, there's a reporting structure where they have to report to a police station. if that person is also on an order of supervision, there's the additional requirement that that person reports on the order of supervision. Well, increasingly what we are finding is that, especially in the police, in the police service, is they're not willing to treat with the immigration matter. And so the court asks the person to report to the police. They will deal with that matter. But they will not deal with the immigration matter where that person has to also report on an immigration matter. They say it's not a case for the police. So we've had instances with that regard too.
I appreciate that, but I mean, I'm just drawing on my own experience here. And for example, somebody who is subject to a detention order, who is applying for bail in the High Court, we see the immigration officers there assisting the court together with the police officers in determining whether that person should be granted bail. And if the court then decides that that person is granted bail, is to be granted bail, then representations are made to the chief immigration officer to allow that person to be conditionally freed in accordance with the terms of the court order. So it seems as though there is a parity there, or a working together of both arms of the state. Is it that there has been a formal request to the commissioner, so we are simply relying on the good faith of the officer who happens to be at the desk? And if that is the case, would a formal request help?
Well, there's no formal structure in place with respect to instances like what you're suggesting. So it may be something that may be up for discussion, where we can probably have a discussion with and see what we can come up with, so that there may not be a sort of a dual reporting for the individual. So it's something that, you know, that we could look at as well. Now, what we also have to look at too is the fact that the order of supervision has a specific date that that person has to report. So what happens if that person reports to the police station, and under the requirement of the Act, where the section of the Act where we would place a person on that conditional release, which is 17(1) of the Immigration Act, we have to renew that order of supervision. So that in itself may be an issue, whether the police may want to renew that as well, seeing that it forms part of the Immigration Act.
Thank you. I believe I want to get Mr. Anderson Jerome involved in this. You're from the enforcement unit. So my simple question is, how effective is this unit? And with respect in dealing with those released on, have conditional release, those detainees released on conditional release. How effective is this unit, the enforcement unit, in dealing with those detainees who have been released conditionally, in other words?
Once they have been released on the order of supervision, we are the ones that basically monitor their movements in terms of, okay, if I'm telling you that you need to report to us every week, we give you conditions in terms of what day you're supposed to report to us. Depending on the person itself, depending on what matters you have, depending on the type of character that the person is, we determine if it's going to be like for once a week, once a month, every 2 weeks, in terms of their reporting condition. Now, we have some people who may not have criminal matters, right? However, there are people, members of the public, who will have reported these people. And they might be fearful of these people who are now loose. And just need to have a little assurance to know that, okay, the immigration department at least is looking at these people. So with respect to effectiveness, we do what we can and what we are at liberty to do and what we have within the ambit of the law in terms of their detention and their release.
So how are these persons assessed to know whether they are at risk? And whether, is it that you're just looking at this person and determining that this person may be at risk for the public? Or is it that you have persons coming in to assess these persons? Are they assessed with their behavioral pattern, a psychological behavior? What it is that you're looking for to determine whether this person should remain in the detention center or be released?
Most times, it is based on reports that have been made by members of the public to the Immigration Division. For example, if it is, you have someone who has been violent towards, let's say it was a matter where the police picked up this person in an abusive relationship, it will be against our good conscience to let's release that person, knowing that the person might go straight back to the person who they're abusing. I mean, if it is we have somebody who's willing to take care of that person and taking responsibility for that person and say, okay, I'm responsible for this person to report to you all on whatever time, we will also make sure that this person does not go back to the person that he's abused or she has abused over the cases. And we get this in a form of a statutory declaration stating, okay, I will make sure that this person reports to you all. Those are the types of things that we take in consideration when we try to decide who we're going to be released and who's not going to be released.
How effective is this bond that the person is placed on? Can a person also breach a bond?
The bond is basically a security deposit. For example, if it is a person is or has a good outstanding court matter or immigration matter, and we put this person on bond, we say, okay, we're going to release you conditionally. You have to pay a security deposit, basically, so that in case anything happens, you've been already deported and you are not compliant. We have the funds now to deport you. Once a person breaches the order of supervision, there are provisions within the Act which states that the Chief Immigration Officer can retain the funds that the person pay for their repatriation, and it is forfeited to the state.
All right, thanks, Chair. So I want to get something clear here because you mentioned, Mr. Jerome, the bond really comes into effect as a fail-safe for someone who may reoffend. But from my understanding, once a foreign national, once a foreign national, in particular extra-regional foreign nationals come to Trinidad and Tobago from certain countries, it's mandated that they pay a bond, regardless of whether they are offender or not. Once they are coming into Trinidad and Tobago, they have to pay a bond. That is my understanding.
That is incorrect.
Okay, are there countries where foreign nationals come into that once they enter Trinidad and Tobago with an intention to stay, they must pay a bond?
The persons who are entering Trinidad and Tobago who are required to pay a bond are those people, for example, who are married to citizens of Trinidad and Tobago, and they are going to be in the process of applying for permanent residence. They are required to pay a bond because they will be here beyond the time, and most likely their tickets will have expired, or they may have a one-way ticket, and therefore you need to have some sort of security in case they need to go back. But other people coming to the country, no, they are not required to pay a bond.
Okay, thank you.
Yeah, thank you very much. 3 quick questions. What is the capacity of the IDC at this time?
Hi, good day, Mr. Ambarat, Vice Chair. The capacity of the IDC is 110 male and 36 female.
110
male, 36 female.
So you might be up to capacity right now.
No, so we are a little bit on the.
Right. I was just calculating. So it sounds so far that the order of supervision is a problematic area. But assuming you were to keep all those persons, the IDC would not accommodate it. If I work it out, because it costs right now about $8,000 a month per detainee. So if you had to detain all those persons, the 2,000 from last year and the 200 from January, you're talking about $219 million a year, $18 million a month. So it is a significant cost. Now, part of the work of the committee is to see if non-custodial sentencing could do, among other things, reduce the cost. But this is an area where the non-custodial is not working, and the cost of the custodial sounds prohibitive. Am I correct?
The cost, of course, will always be an issue in terms of the numbers that you can maintain. If we were to keep 2,000 persons, you're talking about increasing the staff, finding alternative accommodation. There have been times when we have resorted, when we have a whole lot of persons that we cannot yet release because for one reason or the other, we have used the Eastern Correctional Facility, which the minister has declared as a place of detention because the Act sets out places of detention. We avoid as far as possible putting them in the prison. So it is going to escalate. We find that more and more persons are coming into the country and breaching the terms and conditions of their landing certificate, remaining in the country illegally. More and more you see persons entering the country illegally without documentation. And that is providing a significant headache for us because there is nowhere to keep them. Persons have come forward in certain instances to make representations and said, yes, they will care for them, depending on the nationality, etc. So from time to time, we review the persons at the detention center to see if we can release them on an order of supervision. Sometimes persons come forward and say, yes, we will take care of them, etc., etc. When we do our checks, they're not there. But it is a problem for us. And we have a very small detention center compared to the number of issues and the number of persons that we find in breach of the Immigration Act. The capacity of the detention center ideally is 150. But it can go to 200, and that's really pushing it, and you're talking about cramped conditions thereafter. So we try to keep the number to 150, so that is really doing a risk assessment to see whether or not this person needs to be at the detention center. So that's why we have more than 2,000 persons on an order of supervision. But even that, when we put them on the order of supervision, they simply do not come back to us. Some of them do, because some of them who may want to come back may have breached the terms and conditions, overstaying, but married, have families, whatnot, willing to go home. We put them through the special inquiry process, because the intention really is to get them out of the country. And we put them before a special inquiry officer in the shortest time possible, so that we can make a determination as to whether they are to be ordered deported or to be given voluntary departure. Some persons comply with us after the special inquiry. They buy their tickets, they go home. Some persons are determined not to leave and file several motions so that we would not effect the deportation. A lot of them end up at the detention center, but then that could, almost at a stalemate at that point in time. We are ready to deport you, to effect that deportation order. Everything is in place, and you refuse to leave. And therefore, what do we do in those circumstances? They remain in detention. So there are a number of challenges within the system. Either place on order supervision, we can't keep them all in detention. It's either we ignore the fact that they are legally in the country, which is not our mandate. We have a mandate to enforce the Act. And turning a blind eye really is not the solution to it. But we find ourselves sometimes between a rock and a hard place, because even the capacity of the ECRC, and I go back to 2016, when we had nearly 400 persons in detention. But at the same time, we had 2,000 persons on an order of supervision. So the numbers can fluctuate. We, at this point in time, are not conducting any exercises, because I can tell you if we were to conduct an exercise today, we would perhaps find at least 500 persons in breach of the Immigration Act.
Well, the question I'm anxious to ask you is this. Would you say that you are giving this order of supervision because you can't accommodate people?
In effect, yes.
Right.
And it's not the ideal situation.
No.
But let me say one thing too,
go
and
ahead.
this is where the police have actually tried to accommodate us in keeping some of the persons at a police station until we can identify and get travel documents and whatnot, and perhaps getting a security deposit posted for them and being able to release them.
In this group of 2,000, on average, how long have these people been in the system? Like, the longest person in that 2,000 will be how long?
We have persons ranging from mere weeks, days perhaps, to year, maybe more. Those persons who are there for a year or more are persons who are the subject of court matters, where they may have civil or criminal matters before the courts. All right, and the only way we can monitor them really is to have them placed on that order of supervision.
I'm sorry, Mr. Hariku, but the question posed by the Vice Chairman was, what's the longest time that you have someone in detention for? Who is the longest imprisoned person or longest detained person? How many years?
Good morning, ma'am. We have one person in the IDC since January of 2015.
And that person is from which country?
He's a Nigerian national, ma'am.
And does that person have matters before the court?
Yes, ma'am.
Okay.
And the order of supervision. The reason I'm asking this is because the chief immigration officer has mentioned people go off and get married and have families. So you have persons who are under an order of supervision who have gone off and have established families in Trinidad and Tobago.
That is correct. And those persons may be entitled, there's an entitlement under the Act if you are married to a citizen of Trinidad and Tobago to apply for permanent residence. It doesn't give you the residence, you just have an entitlement to apply. However, there's a requirement that you are in the country legally. So what happens, they already fall into a section under Section 9(4) of the Act where they would have breached the terms and conditions of their landing certificate or whatever, and they are deportable. What we do in instances like that, we place them before a special inquiry officer. More often than not, based on the deliberations at the special inquiry, they can either be given voluntary departure, which means they can leave and re-enter to pursue their application for permanent residence. Those who are ordered deported, it depends on what was the outcome and the decisions and at the special inquiry. Of course, if they were ordered deported, there is a provision for them to appeal. More often than not, if somebody appeals the deportation order, they will be assessed to determine if we can put them on an order of supervision. So there's a process, even if they are married to a citizen of Trinidad and Tobago, there is a process in terms of applying for permanent residence, which would then allow them to stay. Just being married to a citizen does not mean that you can stay. You have to ensure that you are coming to immigration, you apply for permanent residence because the provisions are there.
In your experience, what would be the person who has been on an order of supervision for the longest period? What would that period be?
We have seen persons on orders of supervision for as much as 3 years. And as Mr. Hariku said, those persons are more often the ones who have matters before the court. And they will come to us, we know when the court matter is, and we would await a determination of the court matter. Are they being prosecuted, whatever, are they jailed, whatever is the outcome. But of course, we know that the matter may be adjourned to a new date, another year. So we cannot effect a deportation order or remove the person from the country while the court matter is ongoing. Right now, we are engaging the DPP to find out what we really can do in those circumstances, whether we can effect the deportation But, of course, we don't want to be in contempt of court.
Well, I'm trying to figure out if there are civil proceedings in place and there's no stay of execution from a court, nothing prevents you from deporting the person. And if there are criminal proceedings, let's say a person has been convicted of a non-immigration offense and has appealed and so on, there is also nothing preventing you in law from deporting that person. So I'm trying to understand the rationale for keeping such persons and housing them at our expense in this country.
I don't want to sound facetious. However, when we do try to effect a deportation order, that's when we would receive a writ of habeas. Always at the last minute, we received one recently at 2 o'clock in the morning when the person was supposed to leave the country on a flight at 6 o'clock.
And that cost the government.
And therefore, that cost the government money because the government was paying for the deportation. And that is where we encounter a lot of the challenges in effecting the deportation. The intervention by persons' attorneys, and yes, they have a right. But that's a lot of the times, that is what prevents us from effecting the deportation.
I was just wondering about that because I know that many of the courts have said that once somebody is ordered to be deported, that's it. Even if they resist or they don't want to go, that is really besides the point. Once the arrangements can be made to send them, there is nothing legally preventing them from being sent. So why is it then, or is it that consideration is given to the resistance of someone who is supposed to be deported? And if so, why is that consideration given?
We will have to say that yes, consideration is given to resistance because, for example, we are not in control of airlines. If, for example,
I didn't get the last part.
We are not in control of the airlines. Oh, yes. All right, so for example, if a pilot who is in control of his flight decides that, okay, this person is rowdy, he may cause a disturbance on our flight, I am not going to take him. He is kicking up in the airport, he passes on and sees this person behaving himself in a non-mannerly manner, he will say straight that he's not going to take that person on board. He has to take about the consideration of the lives of his passengers and his crew. So that where it comes into resistance, we have to take that consideration. That's where we have to sometimes escort some of these people. The fact that we also need to understand that they need to have visas sometimes to go to certain countries. If the people, the detainees, I should say, are unwilling to sign certain documents, we cannot sign on their behalf. Right? So that's where expenses come, and we have to look for different routes. Some countries are not willing to have somebody detainees passing through their countries. You have to consider the transit time through the other countries and stuff as well. So besides the legal challenges, we have to consider the people, their willingness to go as well. So yes, they have been already deported, but they have resisted, some of the detainees.
Thanks, Jay. I wanted to ask a question. We have a very good support system in Parliament here, and they provide some research. And from submission, Madam Chief Immigration Officer, you mentioned that there are some issues that have to be clarified regarding preparation for electronic monitoring. So you need some protocols to be in place. So I have a two-part question. One, given that Mr. Hariko has mentioned that around 50% of persons have reached these orders, what is the quantum of electronic monitoring devices or persons to be electronically monitored that you may envision once you roll out such a proposal? And do you have the proposal? Do you have the protocols in place, or would it cost the Immigration Division an additional expense to have an electronic monitoring department, for example?
From my discussions with the director of this particular unit, it is my understanding that that unit will be responsible for the electronic monitoring and not necessarily the immigration division. Therefore,
Sorry to interrupt. The unit is housed where? Is located at which institution?
the electronic monitoring, or
Yes.
because that is a unit that is under the broader Ministry of National Security. I think their office is now on Tragarit Road. So we would have to work out with that unit the protocols, how it would be done. As far as I'm aware, and from what he's told me, the court has to order that the electronic monitoring be done. And therefore, we would have to consider how many persons and under what circumstances we would approach the court for this electronic monitoring. And that's why I mentioned earlier that as part of the conditions of bail for those persons who have been ordered deported, et cetera, and have come into the attention of the division, that the court at that point could order the electronic monitoring based on representations from the immigration division. So there are certain things that have to be put in place because the detention center, as far as I'm aware, was not considered in this and the immigration detainees. However, it can work for us once the criteria set out, once the unit itself that is responsible for this knows what is required from us, because they will have to report to us if anybody has breached the monitoring, etc. And then, so a symbiotic relationship would have to be built with that particular unit. And that is what has to be worked out between us and that unit.
So in a sense, it may not necessarily warrant creation of a separate unit at immigration at additional cost.
No, I don't think it would warrant a separate unit. In fact, the enforcement unit can liaise with that electronic monitoring unit at the Ministry of National Security. So I don't anticipate an additional cost. The cost, of course, would come in with how many monitoring systems would have to be placed, how many persons we are going to monitor. And that can run into maybe a couple hundred, maybe less than that. It depends on how many persons we have at any given point in time. Because even in the detention system, the numbers fluctuate.
Thank you. Mr. Jerome just said that you all don't have control of the airlines. When I look at the stats as at January 18th, 2019, and the number of detainees at the detention center, I saw the highest number of detainees are from Venezuela. We have 82 males and 32 females, which give us 114. We are only 7 miles away from Venezuela. So is it possible that you could use some alternative sort of transport to get these people to Venezuela? And if we were to remove this 114 persons, you will be left with only 39 persons at a detention center. So you know how much cost would have been reduced there. I don't know how you could reconcile it.
Before you answer, there is another aspect that perhaps you could take into account as well. How is immigration dealing with the exodus from Venezuela? Because is it that this 114 here have committed criminal offenses in Trinidad and Tobago? Is it that they have not applied for refugee status? Or is it that they have applied for refugee status? And if so, why are they inside? How is immigration dealing with the breaches of the Immigration Act in the context of Venezuelan citizens who have arrived on our shores?
Thank you, Madam Chair. With respect to the Venezuelans who are currently housed at the Immigration Detention Center, almost 100% are persons who would have arrived clandestine, by clandestine means, not through a legal port of entry. And a significant amount, if not all, we cannot identify. They're coming to Trinidad without any identity documents. So it takes a while for us to in terms of the liaising with the requisite embassy, right, in trying to identify these individuals who have breached the Immigration Act in terms of arriving by a clandestine means.
What is it that the embassy is uncooperative?
No, ma'am. We have a good relationship with the Venezuelan embassy. It's just that it takes some time for them to validate the information, as well as persons who are entering Trinidad and Tobago. Now, we would have them listed as Venezuelans at the IDC. And what we are finding is that they are not Venezuelans. In some cases, they are posing as Venezuelans, but they are really there are other nationalities that are coming to Trinidad posing as Venezuelans: Nicaraguans, Guatemalans, Colombians, and even some from Peru. And it takes a significant amount of effort and time to try and identify these people. What you're also finding is that in some cases, these persons also have significant criminal antecedents in their homeland, serious criminal antecedents in their homeland, and we get that through our partnership with the Interpol Bureau. But again, that tracing takes some time as well.
So it brings me to the point then, what's your staffing capacity like, Mrs. Gandhi Andrews, for this department?
The enforcement unit right now has a total of 30 officers. We are currently short of about 35 immigration officers. So I really can't take officers from some places to put into the enforcement unit, because then I deplete either the airport or somewhere else where. So steps are being taken. We're hoping that Service Commission will give us the staff sometime soon. I don't really want to say my comments on that one, because we've been asking for staff for the last 2 years. But at this time, it is really critical, because we are seeing larger numbers of persons coming in. Every time there's an exercise, last weekend there were close to 100 persons that came in that were detained by police and handed over to us that we had to process. So we do have some short staffing issues, but the staff has been working, I would say, long hours in trying to deal with them, because we don't want to hold them. We can't hold them at a police station for any lengthy period of time either. So they have been going out to the police stations, treating with the persons there, because we can't put them at the detention center. So it is a challenge for us in trying to manage the numbers coming in, and that's why I've stopped them really from doing any exercises on their own, because we just would not have the capacity to deal with it. But it is a significant problem.
What about children? Do you, when you arrest or when you detain some of these people, do you find that they are with children, especially if you have families who are fleeing and so on? How do you address that?
In some instances, we do find children, families. What we're also finding is that there are a lot of unaccompanied minors coming by clandestine means. In some cases, we have been able to partner with the Children's Authority in finding shelters for them. In other cases, the court will rule with respect to, we've had about 3 cases recently where the court has ordered that they be placed in the care of the Chief Immigration Officer. The Immigration Division only has 1 place where we can manage that, and that's at the Immigration Detention Center.
The thing is, Madam Chair, if I may, that recent decision to place the minors in the custody of the Chief Immigration Officer is very troubling for me, because like Hariku has said, the only place I have to detain anybody is a detention center. We do try to partner with some of the NGOs who may be willing to take the children, the minors. And when I say children, they may be 16, 17, right? But they're under 18. And some of them have facilitated us. But there are times when they simply can't. And when we can't find anywhere to place the child at any given point in time, we do not have a choice but to put them at the detention center on a temporary basis until we find either a family who's willing to keep them, and some of them we've engaged some persons who are willing to keep them for us while we make arrangements to send them home. Now, the court has also ordered that we repatriate them as soon as possible. I don't have a line item in my budget to purchase a ticket. So I have to request money from the permanent secretary to buy a ticket to send the person home. And sometimes when there are no releases and we have to wait a while, we waited, what, 2 weeks for the last ticket?
3 weeks.
We've had 3 weeks.
And that was because of prodding.
So we do have challenges with getting the funds made available to us in a timely manner to effect the repatriation. So that's the other side of the challenge when we have to purchase a ticket. Some persons have come forward and bought a ticket for us. Some of my officers in certain cases have actually put up money and bought a ticket just to be able to get the person out of the country. And like I said, that's where we find ourselves. And sometimes people don't know all of these things when my officers have done this because they don't want people to know. But we have had to resort to doing that kind of thing. Especially we don't want to wait 3 weeks to buy a ticket to send somebody home. You know, especially when you're dealing with a minor. So that's part of my challenge.
Yes. I don't want, there's so much more that we could talk about. But I don't want Mr. Husbands and Ms. Bernard to think that we're only here to talk about immigration department issues, but the committee does hear you with respect to the fact that you have to wait for funding from the permanent secretary of the Ministry of National Security. Is there an average time, just before I go to Vision on Mission, is there an average time between request and compliance, or is that all up in the air?
Once finances are released from Ministry of Finance and we have funding available to us, I will say we usually have a good relationship between the staff, between our unit and the permanent secretary staff. Let's say a week to 2 weeks. Once again.
Once if finances are not available. It's years, isn't it? It can come up to years. It has come up to years.
I wouldn't say years. I would say it will be a long time. If it is, we don't get releases.
Sometimes what we've had to do is to try to transfer money from one vote to the next in order to purchase the ticket. So whatever releases we might have had remaining from even salaries, the accounts unit have had to ask to transfer some of that money to the vote in order to purchase the ticket. So.
Thank you all, but I don't want you to leave quite as yet. So, Mr. Husbands, if we can get to you and Ms. Bernard. Now, you had said in your submission that you sent to us that not all offenders should be sent to prison. Well, I think everybody in Trinidad and Tobago will agree with that, as some of them can be punished and treated in the community. What we wanted to get an idea of is what kind of offender or what kind of offense are you looking at for that kind of punishment and treatment in the community?
Sure. As I indicated earlier, it will be a minor offense. Minor offenses such as you may find people who are for break and enter, right? Some of them are found trespassing. Some of them they might have stolen a chain from someone on the road, while people might frown on that, but no weapon was used, right? The person wasn't damaged. All these things you take into consideration. And of course, that person should not have a previous court record. Right? So those persons we feel, that can be given those non-custodial sentences. But it's something I want to identify. A non-custodial sentence must also satisfy the justifications for punishment. It's not that we're just going to say, all right, you fit the non-custodial sentence, but it must satisfy the rehabilitation needs, the deterrent need, the incapacitation need, and you also have to take into consideration the victim, how the victim feels about it. So all these things must be taken into consideration. And of course, it would cost us less, but not tremendously less, Madam Chair, because if you're looking in terms of that person must also seek rehabilitation, you must have those rehabilitation centers, you must have trained persons to do that, and the quality of supervision, the level of contact, the human aspect in terms of the supervision still remains, Yes, you can use our electric monitoring, and you can have that person located, the persons in Belmont, but what is the contact? When that person comes to the reporting center, the probation department, what is the interaction? What are the goals in terms of that person coming? Is that person, when that person comes to the rehabilitation center, is that person going to choose something like you call thinking and rehabilitation or reconditioning? Those things are important in terms of those alternatives. So despite the fact you are not going to prison, you still need to satisfy those different needs of sentencing.
Yes. I just wanted to get your views on this. On the one hand, for more serious offenses, we see that offenses are getting stiffer. And at the same time, we are talking about restorative justice. Is it your view that restorative justice should be confined to the minor offenses?
Sorry. Madam Chair, certainly not. There are a lot of programs that can be developed to deal with serious offenders, particularly while they are in prison, even when they're outside. For instance, there's the whole question in terms of a program that is run in most developed countries. They call it the sycamore tree, right? Where you have victims, right, can come in and have panels with offenders, not the primary perpetrator. You're looking for more or less surrogate perpetrators and surrogate victims. But for instance, if you have about 20 inmates within the prison who have been convicted on sex offenses, right? You can have victims who have also been victims of a sex offense. They can have an opportunity to come in a controlled environment to have a dialogue with those offenders who are not the direct perpetrator of the direct offenders. And research has shown that inmates who go through that kind of process develop that sense of empathy. And they are the ones who are willing that when they come out, one of the victims or the community would accept them. They are the ones who are willing to make some level of restitution and giving back. But of course, if these people are coming out, there need to be what we call an intensive probation supervision. And you'll hear me talking about the role of probation, because probation is normally what we call the champions of corrections in communities, community corrections. That is the subfield of corrections, where that continuity and supervision and quality of monitoring, and we talk about the electronic monitoring, that too going to come in play, but it's still going to require the human element to ensure that the rehabilitative aspect continues. Again, if you want to use it for non-custodial sentencing, in terms of the supervision, again, if I know a lot of people are asking for community service at a non-custodial sentence, first and foremost, the non-custodial sentence must match the type of offense. What do I mean by that? You might find someone probably was found urinating, right, in public, and that person is sent to prison, or should be sent to prison for 30 days or 60 days. You can place that person on a community service, but that person must be working in a dog pound to clean that dog pond so we don't understand the scent and, and the conditions when he or she urinates. And, but more than that, you also have to find out if that person has any kind of challenges. If that person has a mental disorder, or why that person is doing that. So that divert that person to a treatment facility as well.
You raise a very interesting point, and that is to say the role of the probation officer in all of this. Now, we had the chief probation officer before us earlier on in this inquiry, and it was quite apparent that the office is quite understaffed and is not running at optimum. What is the relationship between your organization and the chief probation officer's department?
At the moment, very little, if any at all. I go back probably 5-6 years ago where the former chief probation officer, Ms. Claire Blandin, had taken an interest in terms of understanding what NGOs do and ensuring that if there's any sort of training, for instance, in the prison service, when the prison service was conducting training in terms of the, what you call the cognitive behavioral therapies, moral recognition therapy, thinking for a change, substance abuse, and all those, right? They would incorporate the probation department and all NGOs to train them to develop that kind of synergy, because in corrections, there needs to be a joint approach with probation and the prison service and NGOs in terms of preparing, even in the court, preparing the way forward in terms of administering those kind of instruments to decide who are good risk for community sentences and those who are incarcerated, to work together with the prison service to develop re-entry plan, because re-entry plan is a crucial aspect in terms of offender management, in terms of, again, what are the risks, what are the needs, how can we match that person with needs and resources, under what level of condition, how long the supervision is supposed to be, can we send that person right back to the home, or should that person go to a reintegration center? We don't have halfway houses yet, so we don't send people to spend the last part of the sentence in halfway houses. It's after they have completed their 2/3, after remission, then if they cannot go back to the homes, then Vision Mission steps in and provide that transitional care and support with employment and other kinds of services. So it's a whole rethinking in terms of offender management and the kind of interventions we need to make, not only in those in prison, but those who we keep in the community.
Yes, we have a question from a member.
Mr. Husbands, I just would like to find out what mechanism is currently in place to track the progress of ex-offenders following their period of rehabilitation?
I can speak, I would say I speak from the cap of a former chief prison welfare officer. There was a 2-year tracking device by the welfare department within the prison. Right? Now, the kind of tracking that is done, I cannot speak to it correctly. But those who come to us, we do a 3-year tracking in terms of if they come to us, transitional housing. We try to keep them there for 9 months, even a year, even longer. If we get employment for them, we're going to track and work with the employers. When they have transitioned or graduated out of our transitional homes, if they go in the community, we keep a 2-year contact with them in terms of having our caseworkers make contact. If there's any kind of relapse, they can come back to us. So we keep that kind of tracking. And what we recognize as well, in doing that tracking, you can also continue to divert them for services. Some of them may relapse, some of them may need substance abuse treatment again, some of them may have mental issues. We then become what you call the medium, so we can get them back to treatment.
You said you try to get employment for some of those persons who have been rehabilitated. Is it a question of the employers being a little hesitant in employing these persons, or is it that they willingly employ these persons?
Quite a number of employers are indifferent, and I have no problem with it. They have their other workers to protect, but then there are some of them who are very willing. Some of them who work with us, some of them who actually come to us and say, I'm looking for a driver, I'm looking for a next person in that particular field. Do you have someone who fits the bill? What we do, we look at the person's development because we too operate a aspect of the level of service case management inventory where we look at the person's motivation, the change, and the like. So if we believe that person is a good risk, then we would recommend and we take that person for that kind of employment. But it must be done in terms of the level of risk, right? And you must be able to monitor it, and you must be able to evaluate, and you must have the kind of personnel to continue to work with those persons as well.
Yes, thank you, Sanjo Bika.
Thank you, Chair. Mr. Husbands, employment is key, I'm assuming, to prevent recidivism. We don't want reoffending to happen. Do you have any statistics? Because we're seeing here 4,339 former offenders over the last 5 years from your submission. Do you have any statistics on the percentage of them that are unemployed or employed?
Right. I will hand over to Ms. Bernard to apprise you of our stats.
Good day, everyone on board. All right, so the question, currently, that was for the past 5 years, right? The 4,339 inmates. So currently for the year 2018, when we look at our clients, we operate a CPEP program. So that is our starter employment. So after they go through the initial assessment, we source employment from there. Currently at our transition house, all of our clients are employed.
How many are at the transition house?
Can you repeat the question?
Can you say how many clients are at the transition house at the moment?
Okay, currently the transition house holds 90, but currently we have 23. But we also have walk-in clients as well.
All right, so I interjected, but did you have any statistics regarding the total percentage that have found employment from over the past 5 years from that statistic? Or that are unemployed, at least?
Okay, so 60% of our clients over the last 5 years will have gainful employment.
Okay, so then we're looking at a figure over 1,500 persons finding challenges to get employment. You mentioned, Mr. Husband mentioned at the beginning, business incubator. Is it that this is at the idea stage, or you have developed it to the point where you have stakeholder interest, namely training and development personnel, as well as a lending agency that has capacity to lend to them?
Okay, it's that's why we call it the incubator, and that's why it's at the stage in terms of developing. And the reason why we are now getting into that particular aspect is that this requires a certain amount of funding, right? And we are just partnered with the EU who have given us a grant, so we can now think in terms of developing that entrepreneurship program with our clients in our pre-release program within the prison. So it begins here where we're going to identify those who seem to have the mindset. We have already met with a service provider, an expert in terms of entrepreneurship education. That person worked with the EU before and has done a lot of work in Trinidad and Tobago. Up to yesterday, we met with her to flesh out the curriculum in terms of the in-house, and then to actually train those who we believe have the right kind of ideas and are willing to get into the entrepreneurship, to be coached and provided the kind of pathway to develop proper small businesses. And we also, part of that funding, going to provide some level of seed capital as well for those participants. As well, there's the aspect in terms of social development. They also provide, social development, yes. They have a seed project, right, where we also going to be working with social development so that they can get additional seed capital, so that we hope that's going to bring certain amount of sustainability to the idea in terms of developing entrepreneurs. Because a lot of the inmates cannot go to employers to get employment, so we believe if we can start that entrepreneurship. And in addition to that, we have a 12-acre agricultural project, which we have already started. We have contracted a farm manager at Wallafield, which will be housing around 80 ex-offenders who are going to be, in terms of the part of the transition, when they get there, we're also going to introduce them to agriculture, and we're hoping also to expand it to our agro-business entity at Wallafield. So that is the plan in terms of that entrepreneurship incubator project.
Then really and truly, vision on mission is on the right mission. That sounds well.
I would like to think so, Member Obiga.
Okay. I think we're coming close to the end. And I just have one question to Vision on Mission. And that is, because your Vision on Mission is not heavily involved in non-custodial sentence, right? Do you have people who come into your program and they're on bonds?
Not necessarily bonds. Some of them who are on bail, right?
Some of them are on bail.
Definitely, and they are in the community and they seeking work. Some of them cannot go back to the communities.
Right. So they have not been sentenced.
No, not yet. No.
But are they in the program for when sentencing comes up? They may be able to demonstrate what they've been doing while on bail.
Definitely, and on a few cases, Mr. Chance was called upon to come and say a few words on behalf of a couple of our residents who had outstanding matters in the court.
Okay. The second question is, what percentage of your clientele are deportees?
All right, so currently our percentage of deportees are 35%.
Okay. Thank you very much. I see the chair is coming back, so I'll let her resume her spot.
Apologies. Thank you, Mr. Vice Chairman. At this stage, I will invite each representative, or I suppose a representative from each group, to make brief closing remarks. So, Mrs. Gandhi Andrews, again, I'll start with you.
Thank you, Madam Chair. The division is always keen to ensure that the rights of any foreign national is upheld. There are challenges at times in the length of time that we process, and sometimes it is not from our fault. It is just the circumstances concerning that particular individual, and that is what I would want people to understand. This initiative to include us, or to attempt to include us, in this non-custodial arrangement, and even with the electronic monitoring, would be a welcome measure for us in terms of being able to deal with some of our issues and to ensure that we keep as minimal as persons in detention. Because really the ideal is to keep a lot of persons, especially immigration offenders, out of detention. There are times when we do not have a choice. So we welcome this opportunity to be able to express the challenges that we have, and to say that we are willing to work with the other arms of the Ministry of National Security. We do some work with Vision on Mission and other stakeholders in trying to deal with this issue of illegal immigration and migration as a whole. And therefore, we welcome any opportunity to sit and work out arrangements and what is best for not only the foreign nationals, but the national community. Because a lot of what is happening and a lot of the things that we encounter is from reports from nationals who have raised their concerns and asked the question, well, what is immigration doing about it? So I thank you for this opportunity.
Thank you. Mr. Husbands, I don't want you to think that because we have not spent as much time with Vision on Mission as we have with the Chief Immigration Officer's Department, that we value your contribution less. We have received your written submissions. I think we also ought to understand that the Chief Immigration Officer's Department is a large department with a lot of statutory powers, so we had to spend considerable time with the representatives. Before you close, I want to offer you the opportunity, though, if you feel that we have not gone into any area that you wished to expand upon, that you are welcome to write to us, to put it down in writing and send us an additional contribution to the one that you have already done. Okay, so I'll ask you now to give a few closing remarks.
Sure, Madam Chair, thank you. And I don't feel slighted. There are things that are important, that are urgent, that need to be addressed. It's all part in terms of developing a framework so that we could better treat with all our problems. Back to my closing remarks, I want to thank this Honorable House for allowing us the opportunity to share our ideas on non-custodial sentencing. I go way back, and this had been discussed in the 90s, the non-custodial minimum standard rules and the like, and it is there, but it requires a certain amount of changing of our lens, as it were. We are talking about restorative justice, and restorative justice is first and foremost about transforming our perspectives, right? Transforming our structures and transforming our personnel who work in criminal justice to see things differently, to unlearn the things that are not working, to find new ways of delivering justice. Non-custodial sentences is part of the whole aspect in terms of delivering justice and using it to also punish some of those offenders who are good enough risk to be punished. I'm using the word punish because it is a form of punishment, right, in the community, but it must also satisfy the goals of sentencing and take into consideration the protection of society, the needs of victims, and also the needs of offenders. So it must be a balance, and it must be based on what we call in correction responsivity. Match the needs and the risks with the type of intervention. And I want to thank you, Madam Chair.
Thank you all. I also want to thank the media and our viewing and listening audience for tuning in to this session of our inquiry. At this stage, the meeting is adjourned.